So the first speaker would be Janelle Saffin. She has got a law practice in Lismore and is a registered migration agent. Her connection with Timor-Leste spans over 3 decades, including advocacy for their independence struggle, and since 1999, support and advocacy for state building and development. The advocacy continues, supporting their struggle to secure their maritime boundaries. Janelle has been an advocate regarding the dispute in the Timor Sea and has worked as a legal advisor and now active in the community engagement on this. With Inez Almeida, Janelle is an associate producer of the progressive filmmakers Mandy King and Fabio Cavadini's compelling documentary, Time to Draw the Line, which covers this dispute and much more. It's playing in cinemas across Australia right now, and some of you may have seen it recently in Sydney. In her term in the New South Wales Legislative Council, which was 1995 to 2003, Janelle seized the opportunity to advance the cause of the East Timorese, gaining strong support across the political spectrum. She also helped establish and become the Chief Advisor to the East Timor New South Wales Government Task Force. This cross-party support continued in the Federal Parliament when Janelle served as the Federal Member for Page between 2007 and 2013. As a senior advisor to His Excellency Nobel Peace Laureate Jose Ramos Horta, she worked across all sectors of government and civil society, and in 2006 was liaison with the International Stabilisation Force. And Jose had those several posts. He was a foreign minister, a defence minister, a prime minister and president. In addition to her Timor-Leste work, Janelle has extensive engagement in Burma, Myanmar, across all levels of society, and in particular constitutional, legal and political history. Her most recent work was to provide a professional development program to Rakhine State and Union Parliament MPs, Shan State, Regional and Union MPs and Union Parliament MPs.
Because they're always too big. Look, I just want to start off by saying a couple of things. First of all, thank you to Peter and Politics in the Pub for putting this on tonight. It's not always easy to get a crowd on an issue when we're talking about the Timor Sea and resources, but there are people who are still interested in the issue of Timor-Leste in Australia. And yes, it is about resources, but it's essentially about the relationship between Timor-Leste and Australia, and over a long period of time, and sort of an historical perspective and look at it. And the documentary that Peter mentioned, Time to Draw the Line, we've had screenings going on in different places around Australia, and I've been going to some of those. We've divvied it up, and I have to say, Sister Susan is the star in it. And when I talk about it, as I always say, it's a compelling documentary film, and she's very compelling in the documentary film. And I can share it here because there's one part in it where she says, how low can they go? And it's just so profound. And we had to get it lawyered, defamation, and a whole range of things. And I'm not sure if you know Sister Susan, but we had to take that out. I do. And even though it seems so appropriate and so apt, it was the first time I think Mandy and Fabio, we got it done properly because we were screening it through Demand Film and out there in theatres, so we did get that done. But look, it is quite compelling, and it's not just about the Timor Sea issue, it does tell the story of the relationship. And when Peter was also talking about when I was in State Parliament, of course I was there with Meredith, and I was thinking about her role over all of those years in Timor-Leste and the struggle for independence. And we often all did different things, but all for exactly the same cause. And then when she was in the Parliament, we worked on it together, and she was President of the Parliament, so we were able to do a lot. In the film too, these are funny things I just want to share. Sahe de Silva, who is Stanislao's son, and he's now, a great lawyer up in Timor. He's holding up a little flyer, and it's got CNRT, that was for the vote in 1999. He's going, see, we just, this is the only one. And I'm laughing because actually John Dowd and I designed them, and I got Eric Rosendale to pay for them. For me, I don't tell all this when I'm at the screenings, but we're among friends, so I can share some of the things. And Eric said to me, are we funding some Marxist something? And I said, probably, Eric. Anyway, I just wanted to share those sort of snippets because they're funny reflections for me, and I've now seen the documentary film so many times it's like Groundhog Day, but every time I still get emotional because of what it represents. Now look, what I wanted to talk about tonight, the theme of it is what strategy really for the Timor Sea Justice Campaign. There's two parts to it. And Sister Susan will talk about the community, or she'll talk about, but she leads in a way the community Timor Sea Justice Campaign strategy. And I've worked with the government. I've been a legal advisor, legal and security advisor with the government. I've worked with DLA Piper, the law firm that has Timor-Leste as their client. I was with them for quite a few years, and I now work on a project, part of the community engagement that comes out of Timor-Leste. And but I'm not directed, it's self-directed, and I continue the community engagement in various ways across Australia, with community, with parliamentarians, with organisations, with departments, etc., etc. And the documentary film was one way we do that, and we do it in a whole range of other ways. And in that way, I do tic-tac with the Timor Sea Justice Forum, the Timor Sea Justice Campaign, etc., etc. But they're independent, so I'm not part of them. They're independent of government. Now, one thing people often ask me is, why is Timor-Leste taking this action against Australia? And the way I answer it is because they've got nowhere else to go. In 2002, March 2002, Australia withdrew. Australia's a member of it ratified the UN Convention on the Law of the Sea, UNCLOS, as Timor-Leste did later, and UNCLOS has more countries that have ratified it than any other convention, any other UN convention. And so Australia had ratified that, and that means we agreed to be bound by the law and governing the law of the sea. Now, under that, it's allowable to withdraw from certain aspects of it. And in March 2002, and I always say on the eve of Timor-Leste's reclamation of independence, we, Australia, withdrew from the jurisdiction of the International Tribunal on the Law of the Sea, which is a body set up through the convention, and we withdrew from the International Court of Justice, the ICJ, from the jurisdiction for express purposes of delimiting maritime boundaries, so drawing maritime boundaries. So we didn't withdraw on everything, we withdrew for those purposes. And Australia had happily, been part of that, but watching and where they were going with the debate and discussion with Timor-Leste, they decided to do that. At the time, José Ramos Horta, who is quite a diplomat, he said it is Australia's right to do it, and Dr. Marty Alkatiri, who was the Prime Minister, he said, yes, it is, but it's an unfriendly act, and he was right. They were both right in how they responded to that same action. And I always quote them on that because it really encapsulates it. Yes, it's allowable because otherwise you don't get countries to agree to all of these conventions and treaties. Often they've got to have some latitude, but at the same time, it was an unfriendly act, and that's how I see it. So that happened. Timor-Leste said to Australia from 1999, even before, it said, we want to negotiate a permanent maritime boundary. And Australia has said yes at times, but they've obfuscated the whole way. They were not fair dinkum. You know, even though there's a letter from Mr. Howard to Dr. Al-Khatiri, Prime Minister to Prime Minister, saying that, you know, we'll negotiate permanent maritime boundaries, they just weren't, it just didn't happen, and they obfuscated. And in fact, I was at the International Court of Justice on another case with Timor-Leste when they seized the documents from Bernard Collaery's office in Canberra. He was the lawyer for Timor-Leste. That was another case. And Australia there, you know, Timor was trying to get their documents back, and that went to the International Court of Justice. And, you know, sitting there listening to Australia say, oh no, we've always said we'd negotiate permanent maritime boundaries. You know, they're saying that in the ICJ, and I felt like saying, hello, no, but I didn't sing out, I refrained. Meredith was texting me there too. She told me my hair looked gorgeous. She saw me on telly. So that was the extent of our intellectual exchange. But and then another time we had an ambassador, Australian ambassador in Dili, and he said, oh yes, we can negotiate permanent maritime boundaries, but you know, we don't really have a lot of money to do it. And yeah, we could meet every 2 years and it takes a long time. Yeah, and it might take 100 years. So, you know, there've been comments like that all along the way. And then I get asked, so really, we were never serious from the Australian perspective. We were never going to sit down and negotiate permanent maritime boundaries with Timor-Leste, and I'll come to why. But we were never going to do it. And I'm still answering the question of why Timor-Leste has gone down this legal path, because it costs a lot of money. Lawyers don't come cheaply, I know. I know they don't. And particularly when you're in these sort of cases. And then Timor-Leste in 2002, with a budget of $64 million, they were faced with the situation of Australia wanting to sign the Timor Sea Treaty. Now, the legal opinion, the weight of legal opinion is Bayou Undan, which is under the Timor Sea Treaty, which pipes to Darwin, which Timor-Leste gets 90% of the upstream, and Australia gets 10% upstream. The weight of legal opinion from all commentators is that's really in Timor-Leste's territory. If there was a negotiated permanent maritime boundary. But what do you do when you're Timor-Leste with a budget like that? You're dependent on aid, infrastructure's destroyed. What do you do? What do you do? You sign an agreement that is without prejudice to the delimitation of permanent maritime boundaries and without prejudice to respective claims on either side. So preserving your right and your claims. So they signed that. Then they got pressured by the Australian government to sign what's called another agreement, International Unitisation Agreement, which is really unnecessary. But they were pressured to do it, and by saying, well, we can't really formally ratify the Timor Sea Treaty. And when I say this, I've read all the minutes of the meetings, so I'm saying it from, I was around, but having read and accessed a lot of primary sources. And so there was a lot of pressure on them to do that. And they did that, and that spoke to the Greater Sunrise, the other bigger field that became a point of contestation. And then in 2006, and it was 2007 actually, when they signed it, they signed another agreement, and it was the Certain Maritime Agreement in the Timor Sea. And that covered as well the Greater Sunrise area, the big area. So there's really been a lot of pressure. In the documentary, Sister Susan talks about, she says, well, there was Australia with their lawyers, she said, and there was Timor-Leste with their lawyer. So it sort of...
We saw them going in.
It actually says it, you know, because he's Australia, us Australia, and with our 100 years of government and bureaucracy and lawyers and expertise, etc., and there's Timor-Leste, you know, with barely a stick of furniture or a telephone and having to negotiate these international agreements. Okay, so that explains, gives some background to why Timor-Leste was put in that position. And by the way, I've been at the signing of every one as well. So even with the champagne clinking and drinking and all of that. But then Australia withdrew. So Timor-Leste believed, and I said, and I've said this publicly, I think somewhat naively, that Australia would negotiate permanent maritime boundaries at some stage. You know, they thought, okay, once we get all these arrangements in place and we start something happening, because we've done it without prejudice, Australia will come back, and 5 years have been mooted, you know, as a time frame and all of that. And I never thought we would, but anyway, so when that didn't happen, and so Timor-Leste started to see it wasn't going to happen, but what also happened was CMATS was certain maritime agreement in the Timor Sea that was supposed to get development approval before you could actually exploit anything of those resources. Now, there were three options put forward from there were three options put forward, and it was, we will exploit and draw the gas out, and we will have a floating liquefied natural gas platform in the sea near it. We could have another pipeline that could come off the Bayou Undahan one, and it could go into Darwin, or we could have it going to Timor-Leste. So they were the three ones floating around, and what happened was no one took Timor-Leste seriously about one coming to the south coast in Timor-Leste. So no one took that seriously. And again, you know, I've lived this. I know Woodside. You know, I've known Don Volti, I know Peter Coleman, I've dealt with them all, I know, and the other companies, and I never saw Timor-Leste really treated seriously, even though people raised issues like the depth going through the water, going to the south coast, and, you know, we live in an area like it's volcanic, the whole, I mean, there's eruptions. If you have a look at the seismic maps of our region, there's eruptions all the time, right across, so. That happens. So they were never taken seriously on that. And it was just, it will be an FLNG, floating liquefied natural gas or nothing. And there was a stalemate around that. And that went on for quite some time. And a lot of that's, or some of this stuff is documented in Paul Cleary's book. It's Timor's Oil. So it's quite a good read. Anyway, so that went on, and then to add sort of insult to injury, Timor-Leste discovered, and it wasn't until the end of 2012 when they discovered in a more evidentiary sense that there were like allegations of spying on them during CMATS. And the allegations spoke to Australia was providing aid to do up the Prime Minister's palace, you know, where the Prime Minister and ministers are, and in so doing had bugged certain rooms where the Timorese delegation and Prime Minister and all of them were discussing the CMATS, you know, before it came into being. And Timor-Leste put to Australia, we've discovered this, we would like to talk about this, and I know Prime Minister Guzmão spoke to our Prime Minister Gillard and said, look, we can just talk about this quietly, we don't need this to be a public, you know, event, and let's talk about it. But Australia's response was, I refute the premise of the allegations, you know, and I explained where that comes from, the legalese of it. But then we, Australia, announced it in the media that it was sort of taking place. Anyway, Australia then, Timor-Leste then initiated a legal case saying that CMATS should be voided as though it didn't exist at all because it was done in bad faith. And they did that through, say, the Vienna Conventions, which govern the negotiations and treaties and agreements with countries. So they did it on those grounds. And that dragged on for quite some time. And and there were a few other cases. There was that International Court of Justice case because Australia, as I said, they seized those documents. And when Timor-Leste said to Australia, we have a proprietary interest in those documents because that's the legalese, we have a proprietary interest, Australia said, well, you know, you can go to the federal court. And Timor-Leste said, we're not Australian citizens. We'll go to the ICJ, and I think that surprised Australia. And the interim order that the International Court of Justice gave said all of those documents, and there was some data too, USBs and all of that, had to be sealed and could not be looked at by anyone who is involved in the case, that case to do with the alleged spying. And they also said lawyers' communications could not be interfered with. And again, that was quite profound. That was the first time a judgment had come out which really was saying, we do believe lawyers' communications have been interfered with, you know, in certain ways. So there was that one. And then Australia asked Timor-Leste to drop the cases and we can talk, but they didn't promise to negotiate permanent maritime boundaries. And so Timor-Leste said, we'll suspend them and let's see where we go. And it was called, Australia called it a consultation, Timor-Leste called it a negotiation. So there wasn't even agreement on the terminology. I was in those, so I don't talk about the detail of them because those things are done, they aren't done in confidence. But anyway, they went on for about 16 months and there was no agreement to negotiate permanent maritime boundaries. And these documents that Australia had seized in the national security interest, they gave back at that point. And some people said Timor-Leste should go on with the case, but it became what we call moot. What do you go on with, you know, in that sense? So that case was finished. And then Australia, I think, thought it was home and hose, that it wouldn't have to negotiate permanent maritime boundaries because it doesn't want to. And then there's one provision in the United Nations Convention on the Law of the Sea called compulsory conciliation. And it's like a catch-all, and it allows a country to unilaterally trigger it. It had never been used before, and a lot of people forgot about it. But some Australian academics had written about it. Gillian Triggs, when she worked on issues, international law and the law of the sea, in a paper she wrote with Dean Bielak, various people had written about it. You know, we knew it was there, never been done. And Timor-Leste asked Australia, could we do this together, even though they could unilaterally trigger it. And you know, there was some discussion around that and how that could be done and not done. Anyway, the decision was no, so Timor-Leste initiated it. And can I say, the whole time all of this has happened, Timor-Leste has continually asked Australia, will you sit at the table and seriously negotiate permanent maritime boundaries? And the answer's always been, well, no, you know, it hasn't happened. So they kept going. And so that was triggered. Then Australia in the media said, well, of course we'll go along with it because you have to if you're party to UNCLOS. Although I suppose you can say what you like, but they said we will go along with it. But then they objected on 6 grounds. And they said the compulsory conciliation does not have the right to exist because that CMATS actually precludes any such action from happening because it had a 50-year moratorium clause in there that said we won't talk about or deal with permanent maritime boundaries. Now, the 4 minutes, the 6 grounds, Australia lost on the 6 grounds. So I call it, we died in a ditch, I said. So, died in a ditch, straight over the cliff on 6 grounds. And the 6, and what the Compulsory Conciliation Commission that had formed said was, CMATS was a treaty not to settle disputes. So it recognised that it was, and it said that not to settle disputes. Therefore, that moratorium didn't mean anything. Anyway, the next part of it is that that's going on. In January, Australia and Timor-Leste put out a statement saying that as part of the confidence building measures, Timor-Leste would stop that case, the alleged spying one. And there was another one, not many people know about it, but it had to do with Timor Sea Treaty and tax and sovereignty and all of that. So they would stop them, and Australia has said, we will, in good faith, negotiate permanent maritime boundaries. So where does that leave us? Some people say, and Peter was asking me before, is there room for optimism? And I say cautious optimism. Having seen it before, but this is the first time that Australia has had to defend its position in the Timor Sea with its claim that goes nearly up to the coastline of Timor-Leste based on its natural prolongation of continental shelf. It's the first time it's actually had to defend it before 5 learned legal political people, the 5 commissioners of the Compulsory Conciliation Commission, and it shows there's no legs to it, there's no legal veracity to it at all. You can ask me questions about it, but I've said that would be really hard for even the best spin doctor to sustain what we assert our continental shelf position. I'll finish there, I think, because Peter's looking at me, and I've got a copy here. It's just when Australia withdrew from the international jurisdiction of IPLOS and ICJ. That's a media release that was put out by Mr Downer and Mr Williams, the Attorney General. So I've actually 2002, but I brought a copy with me just so people could see it, and a lot of it, it's a problem. Okay, so I'll leave it at that. Thank you for your attention.